Welcome to one of the wildest split courtroom rides you'll see today. Case 1. A defendant hopping state to state with 7 open cases, credit card abuse stacked on felony thefts, and even an aggravated robbery involving someone over 65 or disabled. The defense says she's got skin in the game with tens of thousands in bonds already posted, a tragic family loss, and a technical FTA because she was jailed here. But will that move the needle for a judge who thinks every 2 months she picks up a new case? And then case 2 slams in. A man asleep at a stop sign fails the field sobriety tests with 6/6 HGN clues, 6/8 on the walk and turn, and 3/4 on the one-leg stand, refuses breath and blood, and he's already got to open DWIs in other counties. The judge's reaction: holy moly. And a $50,000 bond with a warning so sharp you can feel it violate, and she light you up like a Christmas tree. Stay till the end. We'll break down why the first judge denies bond outright, what 14-day extradition windows really mean, why PR bonds can vanish in a heartbeat, and how judges stack contempt time when you keep driving after they tell you not to. Question for you: is the system too harsh on repeat offenders, or too lenient until it's too late? Let's dive in.
Let's go through your stuff. So at the outset, it looks like you're wanted out of state for one reason or other. I have no idea. I know you're going to tell me it's all gumdrops, tulips, and little bunnies jumping, right? But how I get to know you is how you look on paper, right? What I see now, you have a credit card abuse that's open, a felony credit card abuse, a felony theft, 2,500, 2 or more times open, a felony fraud, another credit card abuse open, another credit card abuse open, another felony theft open, an aggravated robbery. Is that it? And then what else you got open out of state?
She has 2 thefts of properties from Houston County, Alabama.
No kidding.
Yes.
What would you like? A unicorn.
Judge, I understand and I see it, but she's got a lot of skin in the game. She's got about, I don't even know how many thousands of dollars of bonds on felonies that she's made. And technically Alabama's just minor thefts. Realistically, we don't want Alabama to spend the money to come get her. She's going to put up her own money. And you know what? She's going to have not only this bond.
Here's the defense's pitch. She's posted serious bond money on multiple felonies, so she's unlikely to run. Plus, that failure to appear wasn't willful. She was already in custody. That's a classic mitigation angle, technical FT versus intentional dodge. But judges don't just look at whether you showed up. They look at patterns. Multiple open felonies across states screams ongoing risk, not just a one-off lapse. And when a defendant's financial exposure is spread across several pending bonds, the court might see that as evidence she's active despite supervision, not a guarantee of compliance. Question for you: does having skin in the game through bond money really prove someone will stop offending? Or does a long rap sheet overpower the financial argument every time?
I know, I mean, she's been feeling it. Her sister got shot in the face, 20-year-old sister shot in the face, and she had her funeral yesterday and she missed it. So
That sucks.
she understands like what's been going on, and she's feeling it.
My sister died.
My little sister.
That sucks.
Her boyfriend shot her in the face with some news. So she's very,
It's
Paris,
awful.
I'm not speaking for you, but is this something where you are committed? And she understands if she doesn't go within 14 days, it's not just this bond, it's everything.
This is where human tragedy meets public safety. The defense highlights a heartbreaking detail. Her 20-year-old sister was shot in the face and buried yesterday. The defendant missed the funeral. Judges do listen to these facts. They're not robots. But mitigation through tragedy has to overcome a harsh legal reality: the volume and seriousness of open cases. Courts constantly balance compassion versus risk. If the judge believes releasing her will almost certainly lead to another charge, then public safety, not sympathy, wins. What do you think? Should personal loss and grief impact bond decisions? When the defendant's history shows repeated known compliance.
But Judge, she's also had similar history in other states within the last few years as well. So we wouldn't feel comfortable releasing her on bond. We have concerns that she would be a danger to the community if we did so.
I think so too, Ms. Smallwood. You've repeatedly shown to us that you don't care about our public. You don't care about our bond conditions. And that is evidenced by your 1, 2, 3, 4, 5, 6, 7 open cases here.
Now it gets heavier. Aggravated robbery, involving an elderly or disabled victim that's qualitatively different from standard property crimes. Courts treat elder exploitation as a marked danger to vulnerable populations. Add the prosecutors. Point. Similar history in other states in recent years. That's not coincidence, that's continuity. The DA's message is clear. This isn't a local problem, it's a traveling pattern. In bail calculus, recidivism, risk plus, victim vulnerability plus interstate pattern equals release becomes a hard sell. Audience check. If you were the judge, would you even consider supervised release? Parole is no bond. The only
let you out. What's going to happen? Historically speaking, every 2 months you pick up a case. So if I let you out in 2 months, you're going to pick up another case. I don't want that to happen. Sometimes we have to protect people from their own selves. You are your own worst enemy. And now I'm going to protect you from yourself. I'm not giving you a bond.
Hopscotch with the states. That line alone tells you where the court's head is. The judge isn't just punishing, she's forecasting. Historically, every 2 months you pick up a case. Under most bail frameworks, the court must consider likelihood of reoffending and danger to the community. Here, the judge adds a twist. Sometimes we have to protect people from themselves. That's a paternalistic but legally grounded stance when a defendant can't stop reoffending. Bottom line, no bond not as punishment, but as preventive. For creators, this is the moment to freeze frame and ask your viewers, is the judge overreaching? Or is this firm, justified risk management?
$60,000 bond. Whose money is that? All these are credit card abuse cases. She's getting money from somewhere, some other place. No. Sorry, man. You're staying with me. Just let Alabama know that I'm not, so that they can come get her. The good news is that you've made bond on these cases. So we now give Alabama 14 days to come get you. If they don't come get you, then they'll file a dismissal. Or has she waived?
She has waived. What date did she waive?
September 25th.
Yeah, so you have actually 13 days. No way, Ms. Smallwood. It's time to pay the.
The judge counts 1, 2, 3, 4, 5, 6. $60,000 in bonds and asks the question everyone's thinking. Where's that money coming from? When the underlying cases involve credit card abuse and theft, the optics of large bond amounts can look problematic. Then there's the extradition clock. Alabama gets 14 days to come pick her up. The defense says she waived and the court narrows it down to 13 days from September 25th. Translation, the window is tight. The stakes are high, and if Alabama doesn't act, charges here can be dismissed, though that doesn't make her free. If other states still want her, viewer question, should interstate coordination be faster for multi-state offenders, or is the 14-day rule a fair safeguard against indefinite limbo?
You really have 2 other open DWIs? Holy moly, mother. Oh. And you got a PR bond on this case? Guess what I'm doing to that PR bond? Guess how high I'm making your bond now, Mr. Gonzalez? Yeah, probably $50,000, dude. You have 2 other open DWIs. You've not picked up another DWI? I'm revoking your bond, and I'm now setting it at $50,000. And I'm going to tell you now.
Switching cases and the judge's patience evaporates instantly. The officer observes odor of alcohol, glassy eyes swaying, and the SFST numbers are brutal. 6/6 HGN, 6/8 walk on turn, 3/4 one-leg stand. Defendant refuses breath and blood common, but it invites warrants, license suspensions, and harsher bond terms. Then the bombshell. This is his third open DWI. The judge revokes the PR bond and jacks it to $50,000, stacking on home confinement, GPS, and an ignition interlock order plus a written affidavit that he won't drive. And here's the hammer. Every time he drives, she can run a contempt hearing and stack up to 6 months each time. That's not rhetoric, that's real jail time on top of the DWI question. Should multiple DWS automatically trigger 0 driving privileges plus mandatory treatment until trial?
Monitor prior to release. Can you file interlock paperwork, please? You're not allowed to drive any vehicle whatsoever. And did he have an interlock on this car now? Because he's probably ordered to have one. So he has 2 open DWIs in 2 other counties now.
Who's this defendant, Judge?
Gonzalez. They gave him a PR bond in this case, ixnay on the PR bond A. And I'm actually going to make it extremely high as well, because that's, Mr. Gonzalez, if you have a drug and alcohol problem, you better address it, because if you don't, I'm going to do it for you. Baloney.
No, I've been looking for programs.
I believe you. Sometimes you start looking a little bit too late and you do catastrophic damage. I'm now going to intervene so that that doesn't happen.
2 courtrooms, 1 theme, pattern matters. In case 1, the judge saw 7 open cases, multi-state conduct, and a risk curve that keeps rising, and chose no bond to protect the public and the defendant from herself. In case 2, with 2 open DW is already pending, the judge torched the PR bond, raised it to $50,000, imposed GPS, home confinement, interlock, and warned of stacked contempt time for even touching a steering wheel. The broader message: courts are done gambling when history predicts the future. Your turn. Do you agree with both judges, or did either one go too far? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.